Great. Mark's on, and he introduced himself. I'll just take a second to introduce the whole session, Sugarbush Leases. We also recently published a Sugar House lease resource. We will maybe spend more time on the Sugarbush lease during the presentation part, but we'd entertain some questions on that. It's very similar in some ways, but there are distinctions. So be aware of that and know that that resource is there. We've got Mark Izzlehart, UVM Extension Maple Specialist. We also have Annette Higbee, a longstanding attorney at law here in Vermont, who's had a great career supporting Vermont agriculture, as well as doing some national policy work out of DC for many years. So we're pleased to have Annette joining us to present. And we'll mention we have continuing education credits available for anyone that is interested in that. You can email myself or Thomas Leahy, and we can figure out the paperwork and accounting for that. If you're interested in continuing education credits as professional foresters. A couple updates that I'll share with you. We have published the schedule for our upcoming webinars. You can see here we are on the 2nd, so that's not there, but from September 16th through to early December, we've got a number of sessions coming up just like this, 1-hour sessions every other Wednesday until we have a little bit of a delay during the holiday season at Thanksgiving. But a good opportunity for people to look at some business development and forest health topical areas related to maple development. So check out the schedule, check out the registrations available online now. And a reminder that we do have this active website where some of you probably went to find the information. We've got a number of business planning resources coming online and calculators that will be coming on over the next several months. So stay tuned to maplemanager.org. Which leads us to today's session. Good session today talking about leases. I mentioned the Sugarbush lease guide, and people that registered in advance definitely had this sent to them earlier today or last night. But please go online if you don't have it. The Sugarbush Lease 2020 is available. The Sugar House lease guide is available. And I believe Mark and Annette will also reference our Maple lease setup checklist, which is available online as well. So with that, I'm going to hand it off to Annette and Mark to begin the presentation and settle in for a nice hour on Maple leases. Annette, I'm going to mute.
Okay, can you hear me? So I know that lots of these, or some of these deals are sort of handshake arrangements, but it makes a lot of sense and is a best practice to actually put your leases in writing. In Vermont, our statute of frauds provides that, you know, any agreement involving real estate for longer than 1 year needs to be in writing and signed by the party to be charged, which is just a fancy way of saying whoever you want to hold to the agreement has to have signed it. So if you're not in Vermont, you should check your own statute of frauds. It may be different. In Vermont, though, you know, the law says it's not in writing, it's not enforceable, even if both parties agree that there was an agreement. So check your own statute of frauds in your state and make sure that you comply with it. It's particularly important to have it in writing and to, you know, to have something that you can enforce to ensure security of tenure and that you're able to, you know, get a return on investment for all of the infrastructure and the work that you're putting into it. It's also important to have a writing because it minimizes the prospects for misunderstandings because lessors and lessees may have different attitudes about practices, use and care of the Sugarbush, and it just makes sense to sit down and go through that checklist and discuss these things to put down your agreement in writing. And Mark said, or mentioned that we've been developing these comments, and I just wanted to suggest best practice for how to use these. They're not designed for you to just print out and sign. It's really important that lessees and lessors sit down, go through them, talk about what they want in their lease, and you can start that with the checklist and then go through the template. And once you've agreed on your template, it's a good idea to have it reviewed by an attorney. Next slide. So I've the next couple of slides, I just did a really quick and dirty lease checklist. And I plan to spend most of my time on those items that have an asterisk. So I'm going to talk a little bit about improvements and a few other things. But parties' description of premises, it's a good idea to actually get a copy of the deed to the property so that you know, identify the appropriate owner. It may be an entity, maybe a private owner, and that you have a really good description of the premises. And you can always your forest management plan, map, that sort of thing. So improvements, this is always a sticking point, I think, in every farm lease, and I'm sure it's the same, or it is the same for Sugarbush and Sugar House leases, because lessees come in and they need to make improvements in order to be profitable. And in terms of what happens to the termination of that lease, if the lease terminates prematurely, how that is compensated. So I'll talk about that a little bit more. Insurance, it's important to have that provision in the lease. Most often includes casualty and liability, and both parties carry their own insurance. Lease term and rent, obviously that should be in the lease, and I'm not going to say much about that because I know Mark Esselhard is going to talk about it a little bit more in detail later in the webinar. So next slide, Mark. Mark.
Yep. Hi. So one thing I wanted to mention about lease term is it's really important from a sugar maker's perspective because of how much is invested in infrastructure. And that tubing system that a sugar maker presumably puts up has a lifespan for sure, but it's certainly longer than a few years. So when we actually looked at leases that were happening in force in Vermont, we found the vast majority were right around 10 years or longer, and that's important. And it's important as a producer that you can communicate that point to the landowner and show not only the dollars and cents of what you're investing in the tubing system, but just how important it is to have a term that will allow you to recoup the investment in the tubing system, and to hopefully have written into the lease that you have a clear pathway to renewing, assuming no major obstacles or violations of the lease took place. And we have also seen leases where there's a buyback clause where you can have a prorated amount for the tubing system. We'll talk about that in a little bit. But I think it's interesting to see that the majority are around 10 years or so. And if you go to the next slide, Mark, when we actually canvassed the producers, we saw that it really falls in line with how often that they replace different parts of their tubing system. So, this graph on the right shows the responses from our producers survey that we did recently. We had over 300 producers respond. And the average interval for replacing mainline was 15 years, about 10 years for laterals. And that, I think, is a compelling argument for why you need to have a lease that's longer than just a few years. Not to say nothing of the actual investment cost, $15 to $20 when you're putting that in. And another factor that you want to think about is the stability of the ownership. Does the party that you're entering into as a producer, does it seem like, obviously there's no crystal ball that will tell you this, but does it seem like the ownership is stable and you'll be likely to continue that lease in the future? Forest management restrictions, we can talk about that a little bit later, but the lease needs to be pretty clear about what the landowner has entered into in terms of agreements, either with the state or other parties in terms of what restrictions they're under, and then the producer is going to need to fall in line with that. You can go to the next.
So back to the quick and dirty lease checklist. So another question, another option to put in a lease is to say that it's binding on heirs and assigns. And this is not a common provision in farm leases. Binding on heirs and assigns means that the lease will continue in force beyond the death of the landowner, or if it's sold to a third party, the lease will continue to be enforced. And I'm going to talk about that a little bit more in a second. Use and care of the Sugarbush, there you'll find lots of elements of that in the lease templates. Default right to cure, you need to define what is a default and whether or not there will be a right to cure within 30 days. And if not, then the lease will be terminated. And then the other lease element that I'm going to spend a little more time on is indemnification and liability, landowner liability and lessee liability. So next slide. So improvements. This is a huge topic, both for a Sugarbush and a sugar house, and maybe even more so for a sugar house where someone might want to come in and do a lot of renovation and upgrading of equipment, expensive equipment. So the first thing the lease should say is whether or not improvements are allowed. Can the lessee of a Sugarbush put in a small shed? Can they, so you need to specify, are they allowed? And most importantly, who owns that improvement at the termination of the lease? And thirdly, who pays for that improvement? Is the lessor going to pay for an improvement to his own property? Is the lessee going to pay for it? Is the lease term long enough to get back a return on that investment? There's also, you'll find in the template, a requirement that the lessee at the termination of the lease remove all the tubing and all the sugaring infrastructure. There's an optional provision to require the lessee to purchase a bond, which is basically just an insurance policy, so that if the tubing is not removed, then the landowner can go to the insurance company, pay. I understand it's fairly expensive proposition to take all that stuff down.
Yeah, and then if I can just chime in real quick, I think a lot of times it's overlooked how much it does cost to remove tubing. I mean, there are some estimates it can cost more on the labor side, almost as much as it does to install it in the first place. But I don't think that often comes on people's minds when they're getting excited and throwing out new tubing and getting going on a new property. So it's best to think about it at the initial setup of the lease, and then you're covered down the road. But it is not a small expense in terms of labor to pull that out.
And then finally, you'll find in the template some provisions regarding early termination for any reason. And it requires the lessor to pay to the lessee the depreciated value of the sugaring infrastructure, assuming that it's still valuable and still could be used by a new lessee. And it's essentially just a straight depreciation, straight line depreciation. Although there are other ways you can come up with a evaluation for the evaluation at the end of in the event of early termination. So next slide. Okay, binding on heirs and assigns. So I already explained that if there is a binding on heirs and assigns provision, it means that the lease will survive the death of the lessor or a sale to the third party. This requires that after you do the lease that you file a memorandum of lease in the town land record. So it's not the full 25-page lease. It's just a one-page memorandum that says, I've had the sort of basic information of the parties. And the point of that is to put third-party purchasers on notice that the land is subject to a lease. And if an assigns clause is not doable, if the landowner is not comfortable with that. And there are some other provisions that you can include. For example, the lessee is notified that the property is up for sale and is given a right of first refusal to purchase the property, or the lessor or the lessor's estate can. Next slide, Mark.
Yeah, Annette, you froze up just a second. Can you repeat that last bullet there about the lessor's estate? Because it got a little choppy.
Okay, so if the landowner doesn't really want to do a binding on heirs and assigns clause, you can still try to protect yourself by asking for notice when the land is to be sold or is being put up for sale, and to request a right of first refusal to purchase the property, or a provision that requires the lessor or the lessor's estate to pay the depreciated value of infrastructure.
Great, thanks. You're coming through good now. I'll move on.
All right. So landowner liability is a big concern, and I think it's important to put lessors at ease with regard to those liabilities. So the template that you'll see says that the lessee is responsible for any duties that are owed to guests, invitees, or trespassers. And the extent of the duty in Vermont varies with respect to whether it's a guest, an invitee, or a trespasser. So if the lessee is bringing in, someone, if they're selling, for example, from a Sugarbush or a sugar house, then they're responsible, their duty of care is to make it safe for their guests and their invitees. And then you'll also see in the template an indemnification provision, so that if there is a claim brought against the lessee and the plaintiff brings in the lessor, that the lessee has to indemnify the lessor for any of those claims, basically make whole. And quite often the indemnification provisions go both ways, so that the lessee can be indemnified for any claims against the lessor for lessor's negligence. And then, so under the new RAPs and other environmental regulations, I've seen it also in the hemp rules, they define person as including anyone having any kind of contractual relationship with the lessee. So it's important to put in the lease a provision that will indemnify the lessor for any fees or fines imposed for failure to comply with RAPs or any other water quality regulations or other environmental regulations. So, and I think we took a second look at this the other day, and I think that we'll probably beef up that provision in the template. But anyway, that's the primary point. So, next slide. I think that's it for me. Oh no, okay. This is just a heads up. So, a lease is important, but depending on the relationship between the lessor and the lessee, you may need to think about additional legal structures. So if the two of you are contributing capital, equipment, and you're sharing net income, it's a good practice to actually set up a separate entity, which would be the sugar production entity. So there would be a lease between the landowner and the entity, and you would do a separate operating agreement if it was an LLC, or a limited liability partnership agreement if it was an LLP, or if it was just a joint venture agreement. You should put that in place. And this is something that we're going to spend a little more time on over the next few months, sort of legal structure to be used or sharing capital equipment and net income and different kinds of business arrangements. So this slide is just a heads up. Oh, next slide.
All right, and I'm just gonna, before we hand it over to Mark, I just wanna thank Annette for turning a pretty dense 13 to 15 page lease agreement into a handful of slides and really providing a real satellite overview. So we'll hand it over to Mark, but I'd encourage you all to prepare some questions for what we can fit in the next, between now and 8 o'clock, but also remind people to check out those documents, check out the details, and then the Ask the Team function is available on maplemanager.org. So if we don't get to things tonight, you can ask those legal questions, and myself, Mark, and Annette can review them, and we'll repost those answers back to anyone that checks out the website. Because there's a lot there, and a lot of it depends. So with that, I'm gonna mute myself and hand it over to Mark.
Yeah, thanks again, Annette. That's great. And I know a lot of folks are accustomed to handshake deals, and they're still quite common. It just, unfortunately, it seems like the progression has come to the point where there's just more complexity and there's more at stake, and it's important to protect all parties. So it's kind of why we're giving it a little bit more attention than maybe there was in the past. And actually, maybe this slide, could have even been at the beginning, because if you're a producer, or even a landowner, really, you have to determine whether or not your property is worth leasing. Does it have value enough to attract a producer? Or as a producer, do you think it has enough of a resource in order for you to invest into a long-term agreement to collect SAP from it? Certainly one of the biggest things would be tap density. How many taps are there per acre, and how many acres are available for leasing? And tree size, I didn't put that on this one, but 50 to 100 taps per acre, if they're all 8 or 9 inches, you have a much smaller anticipated yield for that property than a stand that's been managed over time, and you have some good, healthy, mature maples to tap. So that's important. You want to get some information, and hopefully a forest management plan or even a simple inventory from a professional forester will be available, so that you can estimate what you're looking at to produce. And then the rental rate, that's another big one. How much per tap are you as a producer expected to contribute? And that has been changing as well, and not too dissimilar than real estate. Location matters a lot. And we have an hour-long webinar that we did at the beginning of this webinar series, all about rental rates and how you calculated them. So we won't go too far into that, except to say that rental rates are going to be variable, and they are going to be higher when there's more competition from other producers who also see value in that property, and they'll be higher when the quality of the resource on that particular property is high. Some other things that might attract or dissuade someone from wanting to lease a particular property is power available, and if it's available, is it easy to get power for running vacuum pumps or other essential things in a modern sugaring operation, and whether or not structures are allowed, either permanent ones or temporary. If it's a shipping container with your vacuum pumps and sap collection, or if you're going to be putting in something that's a little bit more permanent, you're going to want to be able to understand, is the landowner open to that arrangement? And if so, what are the limits that you can ask for? And I want to put a plug in for Rob Gay. He did an excellent presentation all about essentially valuing what a particular property is worth in terms of Sugarbush, and you can check that out at the UVM Extension Maple website. So, next slide, Mark. Just an example, access. So access to power, but access to road and how you're going to get the sap out. Not all properties have a nice, easy slope out to good road frontage. So there have been great innovations in pumping sap up and over hills, and it's truly an impressive engineering feat that some of these folks are doing. I'm sure if you asked them, they wouldn't necessarily say they did it just for the fun of seeing if they could pump sap up and over a hill because it's a tremendous expense. So make sure you understand just the basic topography, where the bulk of those taps are, and if you're going to be able to get them out in a good way. And you can go to the next slide. So lease term, we talked about 10 years being the most common. There are lots of private leases out there. There's also some limited tapping on public land in Vermont. In Vermont, it's organized and overseen by the Department of Forest, Parks, and Recreation. They approach it as a license, not a lease, and there is a process whereby you enter into a 5-year license, and then you have the option, assuming nothing has triggered or something serious has happened with the operation of that license, 2 additional 5-year terms. And then after full term of those essentially three 5-year licenses, the applicant or the producer could reapply. And Ned, I think you wanted to mention something about the differences between a lease and a license.
Yeah, so I've seen the Forest Parks and Recreation sort of license template. I just worked on one a couple of months ago, and the license is terminable at will, and the renewal is basically at the discretion of the agency. And I also learned that for public land, in order to get a lease as opposed to a license, you need the approval of the governor. So license is probably about the best you're going to get, but I just wanted to point that out.
Great, thanks for pointing out the difference there. And actually, with the limited number of sugaring operations on federal land in Vermont, the Green Mountain National Forest, they actually do it as a permit. It's not a license or a lease. It's a permit. All right, next slide. So some of the terms that are essential to have in a lease are: when is payment due? And the nature of sugaring is that the bulk of the production happens before, say, April 15th or thereabouts, depending on where you're at. So asking a producer, having a lease that requires the producer to pay before that bulk of their valuable product is made is a little, perhaps an undue burden. So a lot of times the lease rate will be due after the season has come to an end, sometime perhaps in June, or whenever they typically would have their income from their crop. Another common term or element of a lease is when spouts need to be removed. Everyone, I would hope, understands that you have to drill a new hole in the tree every year to collect sap, and the tree, once that sap flow season is over and the leaves come out and the tree starts growing again, the tree is naturally going to try to heal over that wound. And if there's a spout in that hole, it will delay the tree's healing process as long as it takes until that spout is taken out. The tree will eventually heal, but it's best practice to have those spouts removed. Now, if you have a lease or a license agreement for 100 taps, it shouldn't take you very long to pull those. If you have 10,000 or 50,000, you want to make sure that it's written in a way that is reasonable for the producer to be able to get all that done without being so open-ended that they are not being pulled. So I just included a little bit of language here that have been in other leases after the season. That's pretty vague. 60 days after the last sap was collected, that's fairly specific. And ASAP is another way it's been described. But have a conversation, make sure. I think landowners really appreciate understanding as much about the process as possible, and that's a good conversation or a point of conversation. Next slide, Mark. Yep. So Annette talked about this a little bit, and it's definitely talked about in our checklist and the lease template. But what are allowable and what are prohibited practices? And specifically, when we're talking about sugaring, we're talking about trees. There's trees are a competition. It's a competition for light, water, and nutrients. And a carefully managed forest is going to be healthier. It's going to be more resistant to disease and forest pests. And so good practices are important. But it's also important that the landowner and the resource is protected from overly aggressive practices or too much vegetation management at once. So make sure that it's clearly stated what can be done in terms of removing trees. If there's a diameter that is allowed or not allowed to be removed. It's very important that the next generation of trees are not just cleaned out as a matter of making the woods easier to navigate. Things should be fairly well stated what can be removed and what can't, and then what requires consultation. Probably one of the best ways to know what's allowed and what's not is to reference a forest management plan, and a lot of these properties are going to be in some form of forest management in terms of reducing property taxes. So there are also a variety of sugarbush management standards that can be referenced, and those are written there below. You can go to the next slide if you want. Okay, yes. So as Annette mentioned also, with RAPs, there's also AMPs. So we are dealing in a forest. There are acceptable management practices for logging operations, mostly in terms of water quality and making sure that stormwater and others are carefully managed and you're not getting erosion and getting material in the waterways. The picture on the right is actually a couple of county foresters looking at a sugaring operation that has some woods roads, trying to understand where to put in some water bars. And that little two pieces of wood at the bottom are actually illustrating what an appropriate angle for a water bar is, and they're trying to figure out where the best place to put that water bar. So it's important too, if that property is in an arrangement like use value or some other property tax abatement program, that something the producer does won't put the landowner's entry into that system at risk. So that's important to make sure to know about. You can go to the next slide, Mark. Actually, you know what? Can you go back 2 slides, Mark? I think we may have skipped over one real quick. Yeah, so there you go. The other really important thing is what diameters are allowed to be tapped. And this slide kind of shows you the range. You can have something like the organic standards that are widely used in Vermont. I think about 80% of all the organic syrup in Vermont is certified by the NOFA Vermont. And they allow one tap as far down as 1 inch in diameter at DBH. And if you take it to the other extreme, the tapping guidelines for Green Mountain National Forest permits require nothing smaller than 12 inches in diameter. And there are different reasons that they've come up with these different standards, but it needs to be stated expressly in the lease. That way you avoid confusion, and it's something that really should be clear for both the landowner and the producer. Now I think you can skip ahead to Mark.
Okay, Mark, do we catch them all for you?
We're good, yep.
Okay, great. All right, Mark Cannella back with a couple more topics, and then we will open it up for questions. Annette and Mark have covered the lion's share of this. What I did want to add a couple considerations for business management at large in relation to the lease. So I think lender requirements are something to be mindful of. It was mentioned earlier that the timing of the payment in a lease is a really important aspect of any lease, but in particular maple lease, where we know that the production is seasonal, and in some cases the income generation from some people can be highly seasonal and possibly concentrated. So as we mentioned, the idea of the rental payment should be specified in the lease and should be a conversation about when that money would be available from the producer. I think it's also a great thing to think about the lender and the timing if there's any financing involved as well. In Maple Country, we know that lenders often have flexible or customized payment structures for a seasonal income generation type business. So that timing is important. Knowing when the cash will be available to make the payment that satisfies all parties is important. The idea of a lease as well is important in speaking with a lender or a prospective lender. If you're looking to start up a new business, having the conversation about what their expectation is for land tenure and how formalized that will need to be is a really important aspect for, again, any of these parties. And remembering that the lender is often a very influential and important party to both the operator and potentially a secondary landowner. Earlier, I think we discussed this concept of buyout clauses and the calculations that was mentioned. I'll say that we had a great question a couple weeks ago about rental rates and buyouts, and we expect to put together a few more clear resources or a couple more answers to the Ask the Team to spell out how these things can play out. I think a couple weeks ago it was asked in reference to a rental rate. Is there some way to kind of prorate in embedded infrastructure into the rental rate? Well, now we're going to be talking about how do you prorate the value of the assets so that the lessor or whoever the investor is can get that payment on the back end, whether it's an early termination, or an unplanned termination to the lease, or even if it's a planned departure of the lease agreement, but we know that there's still remaining lifespan on the assets. So these are all things that are embedded in that conversation that introduced the idea of who pays for investments, who's responsible to upkeep or improve or repair them, and then ultimately who owns them if the agreement is terminated. I think it's also important to mention the relationship of lease frameworks and lease formats in the context of succession planning and transfer planning. Again, earlier Annette indicated that in some cases it will be important to generate or to establish a separate legal entity that is going to be the relationship between the landholder, and this entity may be the relationship with the landholder and the lease agreement or the lease instrument. In the concept of family transfer or even non-family transfer and succession planning, I've personally witnessed that leases can be a very valuable tool to formalize the relationship because it requires evaluation on the access to the forest land or the built infrastructure. These are often difficult conversations for families to have, and often these instruments that force you to formalize valuations, formalize access, and formalize the relationship, although it can be challenging, can often be a very productive and essential step in order for these businesses to transfer clearly to the next generation, and also to clearly document the values for the other parties that may not be related to the transfer. And I'm talking about additional siblings, additional heirs of a future estate. The idea of formalizing a lease can be a real benefit in that overall trajectory for an estate and family planning. And I think I probably mentioned this or indicated this kind of with what I was saying, but the idea of structuring the lease with all these tenants that Mark and Annette and the documents laid out, really make it clear what happens, who does it, who has permission to do what. And again, in the context of succession and family planning, family communication, these can be very valuable steps in order to transition a business the way that both parties will transparently understand that the transition will go. There's a lot of things that go unspoken. I think Mark mentioned handshake leases and unspoken agreements. Once you bring this into the family dynamic of transfer planning, so much more is unspoken that would be okay to speak out through the idea of a written agreement. It can help a lot of people. Often not easy, but often can really make it clear, and make it clear when it works, and also make it clear to identify when it's not working, which is another essential aspect of a multi-party relationship, being able to call out when it's problematic. Quick diagram. I could have put this up 30 seconds ago, but I've again witnessed really the successful transition of family operations where multiple entities and multiple legal instruments do come into play in order to take what was the family farm maple that may have been senior or founding owners, and then to say the next generation or the acquiring parties are going to start operating sap production in the woods, and they're going to need a formal lease in order to do that and to manage the relationship and the access to the trees. I've also seen this happen with the sugar house, specifically younger generation taking over, having to delineate the access to the resources in the sugar house via a lease, and specifically these buyback clauses. As another generation is coming into the business and making their own investments the way they'd like to operate, they do need some security on the back end of the agreement to get that recuperation of payment or inevitably future ownership. And then the third entity here to reference Annette talking about different entities, it's common, or at least I've witnessed the idea of a syrup company or a marketing company being peeled away as a separate entity from the farm, but then again, maybe having some sort of agreement or contractual relationship back to these other businesses and these other parties. So this stuff is complicated. It's great to have Annette on to, I think, open us into question session here in a second. It is complicated. I think in general, I think we'll all agree, not only is it important because, you know, everyone says things are important, but it can be very valuable to these business relationships. And it often does require the help of a professional to get it right and to make sure that it's not only drafted correctly, but as Annette referenced, submitted to the right people to make it binding and to have all parties be aware of it.
And Mark,
So
if I
that,
can chime in just one quick thing, it isn't specifically about succession and transfer, but it's more about the conversation the two parties are having, or more than two parties. A few things that sometimes aren't included in leases but might be valuable are, one, things that are really important to be avoided. We talked about areas that are excluded from the tapping, but perhaps there's a favorite road or something. If you work with a producer in terms of developing the tubing system, they might be able to engineer in a way that allows for easy access if it's explicitly put into the lease that certain areas need to have easy access. The time to do it is before the tubing system gets installed and can avoid some of those costly changes. And then more on the forestry side, you know, sometimes there's sort of a conflict or a perceived conflict between forest practices and sugaring. You can have both in a way. Certainly if there are trees that have the potential for veneer quality and really high value when they become mature, those could potentially be flagged and not tapped, and that way the forest management plan can have a little bit more complexity to it and allow for multiple goals. So at that, I think we can probably go to questions, unless Annette, anything last you want to sum up?
I guess I would just say that, you know, there's kind of a spectrum from relatively simple to much more complex, and it's you know, it's a function of size of the operation. It's a function of how much money is invested. It's a function of what the lessees are bringing to the table. But I mean, I can imagine small family operations that could just do a joint venture agreement with an heir to give him an opportunity to sort of build some capital, and then from there, I mean, the beauty of these entities is that they allow you to transfer a fractional share of a business to the next generation. So that's the purpose of formalizing these structures in an LLC or a limited liability partnership. It sets up a legal structure for transferring and for allowing a new heir or a new entrant, I guess, to build equity over time, and to put them in a position where they may, at some future point, be able to actually purchase the land. And that's the other question, or the other point I would make is that, you know, most often, or the best practice, I believe, is to keep the land out of that business operating entity to start transferring, you know, the operating entity as a separate entity. It has liability issues as well, limited liability aspects to it. So that's it.
Great.
Great, thanks.
Well, thanks everyone. Bear with us for a second. We're going to do a couple clicks to give you the option to unmute yourself. So if you do have questions in a second, you'll be able to say them out loud. Encourage you also, if you are more comfortable, to use the chat box. Again, look for the little I don't know, cartoon icon, I guess you'd call it. If it's not there, look for the 3 dots that say more, and you can type in some chat questions. And let's we'll get you all unmuted. I think at this point, everyone should have the option to unmute themselves. So if you want to call out a question, just look for the microphone with a slash through it to click on it so you're unmuted. If anyone's calling in on the phone, it's usually *6, but I don't see any phone participants on. With that, we'll hang a minute and see what comes in. And we've also generated questions from the registration.
I see one question here from David Mance. Oh, let's see. Asking me to speak about workers' compensation requirements in Vermont related to volunteers or per firm workers per diem. So the benefit of workers' compensation is that if somebody gets hurt on your property, they can't sue you. So I mean, I do know that if you are an LLC, you can exempt up to, I think, 3 owners. And I only recommend that if those folks actually have health insurance. So I don't know the current, I have to look this up every time. I don't know, you know, what your payroll has to be or how many workers you have to have. But I do know that, you know, it's workers' compensation. I know it's expensive, but it's of a huge benefit to you. It's cheaper than getting sued for a catastrophic injury that you would be personally liable for. So I can look up those number of workers and payroll, etc., and I'll send that on to Mark, and we'll send that out.
Yeah, we can send that back to everyone that's registered and put it online. Anyone speak up? I'm not seeing my chat may be stalled out. So if Tom or Mark, if you see anything pop up.
Yeah, I didn't even see Dave's question pop up.
I didn't either.
Looks like it's to me privately.
Okay, got it.
There you go.
Yeah, that's how we talk to lawyers. While people are waiting to get the courage up to type or speak, I'm going to read a question that came in. Let's see if I can read this one. Someone's interested in the recommended levels of insurance. Mark or Annette, could you have any additions to the levels of insurance or the types of insurance that may be applicable to a Sugarbush and maybe Sugar House lease?
I think liability and casualty are the 2 most important. And I don't think you can, and we put this in the template, 1 million. I don't think you can even buy a policy for less than 1 million. So that's, I guess that's would be where you start.
Great, casualty and liability. I'm going to, I see one coming in on chat. I'll read it because I have a feeling Mark may need to think about the answer. Is there a resource, either public or through the university, to find land available for leasing? So a question about finding land that's available. And then the follow-up, is there a typical number of taps a leasable property should have?
Yeah, Aaron, thanks for that question. The first part of that question, so I believe that there was an initiative funded through ACER Access to develop essentially a matchmaking process. I want to say it was funded through Midwest. I think Jesse Randall at the time might have been with University of Iowa. Now he's with Michigan State. I don't know if that service or that product is available or not. I would certainly check, or you can do some searching yourself. But I believe the purpose of that was to put people in touch specifically for maple operations. And now I see Mike Gia is posting Vermont Land Link and New England Farm Finder as well. I'm not positive how much of those two services include Sugarbush, but they presumably do have some as well. So the next question or the next part of your question is a little bit trickier, because is there a typical number of taps that they should have? In general, you would want to have something around 50 taps per acre. You can certainly make a go of it if it's a smaller number of taps, especially if the average trees are larger and you're going to have more sap with larger trees. There isn't a real hard and fast rule, and I know regionally it can vary. Certain parts you see a much higher per tap number of taps per acre. It's important though to remember that it isn't always the number of taps per acre that is going to equate to the highest amount of production. And I go back to the small trees sort of scenario, where if you're tapping a lot of the small trees, yeah, you have a lot of taps per acre, but you're getting quite a bit less sap than you would with larger, more mature trees. We have a couple of documents about tree size and yield, and we are in the process of developing a calculator that would allow you to input the average diameter or basal area per acre in your particular stand or one you're looking at leasing, and you would get some estimate, albeit somewhat coarse, but you get some estimate of what the yield would be on that acre. That would allow you to compare different properties and pencil it out to see if it makes sense. As you might imagine, there's a lot of variables. It's pretty complex. There's some real variability there, but please come back to Maple Manager, and I hope that we're going to have something in the next few months to be able to share with people on that calculator side. Good question.
Well, I'll ask one until something else comes in. Annette, I don't know if you can answer this, but for someone who hasn't worked with a legal professional on a Sugarbush lease in the past, can you give just a little bit of a guidance or a ballpark? We know that there's a valuable cost to having a legal professional, but what can someone expect with a relationship with an attorney, and both the process and possibly just a ballpark of what it may cost for something a little more standard, but certainly that needs to go through an attorney for guidance?
I'd say there is a lot of variability, and there's a lot of variability in terms of experience and understanding of both, maple industry and agriculture in general. I would say anywhere from $160 to $225 an hour, but you can save some money by sitting down with a checklist and developing your own template from the UVM template, and then just asking a lawyer to spend an hour to review it. I think that the more you can take to an attorney, and so you're not just starting from scratch, the more money you can save.
Great, that's helpful. Sounds like the lawyers can help with the technicalities, but the landowners have to put the time in to make their decisions first.
Yeah, the other thing I'll note is that Vermont Law School has a clinic, an ag clinic, and Sophie, who there is, looking to take on these kinds of cases, and they're pro bono. They also have what's it called? They have sort of a stable of attorneys who are willing to do pro bono work for farmers. So I would, contact Sophie at Vermont Law School, and either through her clinic or through her, I guess they call it a legal food hub or something like that. And so that would be a good opportunity too.
Great. Thanks, Annette. Well, it is 8 o'clock, so I'll invite anyone that has to leave to certainly start to sign off, but we could certainly take another question if there's anything else coming through the chat box. I see something typing in here. Let's see if we can get it in before we sign off.
And just so everyone, while we're waiting for that to come in, just remember, this series is continuing. We'll have another one in 2 weeks. It'll be about tapping into stained wood and why you don't want to do it. But keep looking back at the schedule, and hopefully we'll see you here again.
Great. Yep. And this last comments come in from Mike. If anyone doesn't know Mike, he's consulted with UVM Extension for years, and also works quite a bit with the New Hampshire-based Land for Good organization, which has an enormous amount of land tenure, alternative land tenure, leasing, and succession resources. So in the chat box, Mike's put a link to, looks like, liability and insurance specifics for farm lease. And he says nowadays it's common to see $1 million per occurrence and a $2 million aggregate coverage. Thanks, Mike. Always great to know you're out there. And for anyone that's not familiar, definitely check out landforgood.org. And there's a whole bunch of resources in their toolboxes that that can help get you along on the way. Great. Well, with that, I think we'll thank everyone. Mark and Annette, really appreciate your presentation. And Annette, thank you for all the legwork on the legal documentation. And as she said, putting these together in a way where you are going to have to answer questions and you can go through the Alex and these guides to decide what's important to you. There's a couple sections where it says 3.1 this way or this way. So we encourage you to think about your specific situation and really get it right for you and whomever you're partnering with. So with that, I'll say good night. Thanks for coming.
Have a great night. Thanks for coming, everyone.
Thanks, everybody.
As people sign out, I'm just trying to figure out how to stop the recording.